Welcome to another episode of Thaddaus Dawson Speaks, where our mission is liberation through valuation. In recent weeks, Thaddaus has journeyed across the country, empowering communities with vital heirs property training. Navigating estate planning with multiple heirs can bring unexpected challenges, but today's program sheds light on solutions. Featuring renowned heirs property attorney Jacy E. Fisher. Let's join Thaddaus and today's co-host Shonnie Alridge as they unlock pathways to lasting legacy and freedom.
Don't get left behind. Preserve the well. Protect what's mine.
Today we have a very, very exciting guest. I know you probably watched several attorney shows. She would be the premier attorney in the South since Matlock. And I'm just a super fan. Her name is Jacy Fisher. Jacy is a senior associate attorney at Gregory Varner and Associates. They have offices in Central and East Alabama. Jacy is also a JAG attorney with the Alabama Air National Guard. She primarily represents clients in the practice of heirs property, real estate litigation, estate planning, and probate. Jacy has a reputation for being a zealous advocate, advocating on behalf of black farmers and landowners faced with involuntary land loss in Alabama since 2021. She serves as an expert roundtable for the Federation of Southern Cooperative Heirs Property Boot Camp. Jacy is also an advisor on the advisory council for the Southern Risk Management Center. She serves as a consulting attorney for the Alabama Heirs Property Alliance and trains university extension professionals on understanding heirs property at the community level with a team that was created for the Social Research and Disadvantaged Center and the Socially Disadvantaged Farmers Research Center and the Policy Center out of Alcorn State. Shonnie and I had the pleasure of meeting Jacy during heirs property training last year in Houston, and she is a dynamo. So we have an outstanding show today for you about heirs property and the opportunities to clear up heirs property. And let's get to it and let's get Jacy out here. I'm going to start with, before we get to Jacy, I'm going to let Shonnie jump in there because I'm always taking up too much air here. So, this is the last thing I'm going to say, Shonnie. I am the best looking man on this podcast today.
And that's true. Very true. Yes, when I first experienced Jacy, because it is an experience, I realized, good gracious, this lady is very, very smart and she knows her stuff. And it would be a privilege to have her to advocate for you, because I think that when you're in this type of space, and Jacy, you can attest to this, but when you're in this kind of space, you have to want to be in this space. It's not like it's easy. It's a challenge. It's a challenge every single day. Different families and things like that. And so it was just really a pleasure to experience you, learn a great deal that time in Texas. Yeah. So happy that you're here.
Thank you so much. I'm so glad to be here. And what y'all are doing is so important and so part of the puzzle. And so I'm so excited to just collaborate with you all and that y'all asked to collaborate with me.
Yeah. Well, we're thankful. Your energy and enthusiasm is quite infectious. And to hear you speak, to have all that power and energy was awesome and amazing, and to hear your passion for the people that you are actually fighting for and educating. And again, it is a fight, and I believe you are making a profound difference in Alabama, and we're so excited to be working with you there.
Thank you so much. I'm excited to work with y'all. I think we've got some exciting things planned for how we can help these landowners.
Ooh, yes. And it's much needed. And let's just jump right into it. Can you tell us, a lot of people want to know what heirs property is. So can you tell us what heirs property is?
Yeah, absolutely. So heirs property, as we refer to it here in Alabama, I know up north sometimes they call it tangled title, which is a little bit different than heirs property. But with heirs property, it's property that's owned by a whole bunch of heirs. And so it's funny because sometimes people will come to me and actually spell it AIR, like air property, like property in the air.
In the air.
No, it's literally
That would be
like
me.
HEIRS. And so a lot of people, they don't understand. I mean, it's what it sounds like. It's property owned by a bunch of heirs. And it's the title is unclear. It's usually inherited by a bunch of children, sometimes surviving spouses of a decedent or a person who has died that didn't leave a will. Or maybe they left a will, but the will did not leave any specific piece to one person. Maybe the will left the property to 10 children in equal shares. Well, that is technically creating heirs property. And so in the South, we see a lot of heirs property, mainly because a lot of landowners are dying without an estate plan. So they're dying without some type of legal document that says where their property should actually go. And so it passes according to state law, and that can vary as far as who's going to inherit. Usually it's all the children, including children outside of a marriage, inside of a marriage, and oftentimes the surviving spouse as well.
Jacy, can you speak a little bit to when people think that they've actually done the right thing and they've actually left the trust, but then the trust isn't properly set up or properly funded and therefore being ineffective?
Yeah, so there's two instances that I think speak to what you're referring to. And number one, that's, let's say somebody creates a trust and they have a trust agreement. They say all the rules and regulations of how this property is supposed to be managed, and they forget to fund the trust. And by funding the trust, I mean that they forget to deed the property to the trustees of that trust. So they create the trust, but they don't actually do what they're supposed to do in conveying the property to the trust. So I get a lot of people that'll come to me after someone's died and they'll say, well, my mama had a trust, so the property was in the trust. And I'm like, okay, great. Can I see the deed to the trustees? And they're like, we didn't do that. And I'm like, well, you didn't fund the trust, so the property is still owned by your mother. It's not owned by the trust. The other instance, and this is the most common thing, and it's kind of like a 2A, 2B. So let's say you have a will, and the will says that the property is supposed to be split into 4 pieces for each of my 4 children. I die and my children don't probate the will. So the will has to be admitted to probate in the local probate court in order for it to be carried out. And a lot of people don't know that they need to do that, or they forget to do it because they're so overcome with grief. But here in Alabama, if you don't probate the will within 5 years, that will is ineffective. So I'll get a lot of people that'll come to me and say, well, my daddy left a will, but he died in 1977. And I'm like, we're past the point that you can actually probate this will. So you need to probate the will as soon as possible after someone has died. And the second part of that is that they may probate the will, but they don't do what we call an executor's deed or a fiduciary deed or a personal representative's deed. This is where the will gets probated, and then at the close of the probate, after creditor claims have been paid, the personal representative or executor is supposed to actually sign and draft a deed conveying that property from the dead person's name to the proper beneficiaries. And I have seen many times that this does not happen, which is concerning because usually attorneys are helping families probate these wills. And I mean, at our firm, we would prepare that deed for the family before the estate is ever closed. And I'm finding that more often than not, that deed has never been executed or recorded in the probate court.
So is that negligence on the estate or negligence on the attorney?
I think it depends. The hard part is I can never go back in time and ask the attorney why they didn't do the fiduciary deed or ask the personal representative why they didn't do it. Some attorneys say, the personal representative is in charge, and so they should be the ones making sure that those things happen. But in my opinion, how are they supposed to know, number one? Like, you're the attorney. So, I mean, your job is to advise them and protect them. I would say that the attorneys are not exercising their due diligence in making sure that these personal representatives are fully equipped with the knowledge that they need to do what they need to do. And I think that some attorneys will get the process started for them. They'll file the petition. They'll get the letters testamentary, which are basically like your certificate saying, hey, I'm the personal representative. And then they just kind of like go away and let the personal representative handle it from there. And so to answer your question, I think it's a lack of due diligence on the attorney's behalf in a market and in a world where courts do not usually let personal representatives or executors probate wills on their own. They usually require that you have an attorney. So if they're requiring that you have an attorney, the attorney should be doing everything they can do to help guide that person through the process.
You mentioned 5 years. It seems like that's enough time to, try to get your affairs in order. So 5 years from the moment the person passes away. So it seems like it's a pretty decent amount of time to get things done. What do you think?
I agree. I think it's reasonable. It's something that a lot of people don't know about, though. Like, that's a law here in Alabama that even I would say the average attorney doesn't know if they don't work very strictly and closely in probate. And I know that, like, the average layperson does not know unless we go out and educate them and say, listen, time is of the essence. Take that 6 months to grieve, but get that thing filed. Because if you wait too long, ain't nothing you can do. I think it is reasonable.
Right. And then, but it's different in every state, though, right? It's 5 years in Alabama, but we're in Georgia, so it could be different.
There could be no time limit for all I know in another state. It could be that there are some states that say there's no time limit at all. But here in Alabama, I think in the name of judicial economy and efficiency, they're trying to make sure that they don't have a bunch of wills probated 30 years later after more and more people have died. Like, if you're probating a will 30 years late, the original beneficiaries are probably dead. Like, then you're trying to figure out who are their beneficiaries. So it can really create more of a mess the longer you take to do that.
Jacy, how do we get out in front of this to help people? I know what we're planning on doing with the Heirs Property training and the Train the Trainer series and bringing exposure to the issue and opportunities, because a lot of people just are not aware of it. And then there's such a significant amount of loss in the Black community because of heirs property and people losing the property based on the fractional interest and then being forced into the sale of the property once somebody sells that fractional interest. And one of probably the most heartbreaking stories that I heard was in Alabama when we were in training about the family whose property had 400 acres that had been in their property since Reconstruction and then lost it recently. And that just did something to me in hearing the story and the loss of value that goes along. And that's where I was thinking about the actual valuation process and how it's impacted in the heirs property. So one of the things that we'll be able to do with the Policy Center this year is offer appraisal services for heirs property, but also to offer market analysis for the after highest and best use for the estate in order to see what the maximum use is. And so one of the things that we have to do, even when you get started with heirs property, to even start the valuation process, you have to utilize a hypothetical condition to assume that there's something that isn't. And that would be that you have the fee simple and full bundle of rights that go along with the property, which a lot of people don't quite understand and how impactful that is. And if you don't have the full bundle of rights with the fractionalized interest, you can't even get disaster relief, a farm number, or anything else to help sort of mitigate situation and circumstance with the property. Can you speak to that?
Yeah, so a couple different things. Number one, I agree that education is still so important, that we get out in front of communities and other community professionals and say, listen, we have an obligation to inform y'all and empower y'all with knowledge to know better so that you can do better. Okay, so there are still a lot of misconceptions and myths that the communities believe. I mean, I had a case where in a trial that was held in 2014, the elders testified that they were told that if they kept the property as heirs property, it could never be sold. This was an incorrect oral history that had been spread down from generation to generation and probably advised, unfortunately, by an attorney in Jim Crow that did not have their best interest. And so we have to continue educating people so that they can be armed with knowledge. But number two, as it relates to your appraisal comment, it is so important to have a good appraisal. And I want to talk about why it's important in this heirs property space. There's a few different reasons. Number one, we use appraisals to clear title. I mean, they are an important part of the clearing title process. And so when we're trying to accomplish what we call intra-family buyouts, where one family member is purchasing the interest of another family member so that they can reduce the number of heirs and consolidate the title to make it clear, how do they figure out what to pay? Like, what is the purchase price of that person's interest? Well, what we do is we take the value of the property multiplied by the fractional interest that that person owns. And so we can't even determine a buyout price without an appraisal. And as you can expect, people want a fair market value. They don't want to use the tax assessed value because they're going to get pennies on the dollar of what their interest is actually worth in the property. So an appraisal serves that purpose in saying, look, this property is worth X amount. We can multiply that by the seller's fractional interest, and maybe someone else in the family can buy out that selling family member's interest for a fair and equitable price. The other purpose that appraisals serve is under the Uniform Partition of Heirs Property Act. So the UPHPA, there is an actual subsection of that statute that requires the court to assess a value to the property before the property can either be partitioned in kind, meaning physically divided, or sold. And so that appraisal process has to happen before any buyout rounds between the family, before any buyout rounds between the plaintiffs and defendants, and before the property will be either partitioned in kind, physically divided, or sold. And so that whole process is where a judge actually appoints an independent appraiser to appraise the property.
Uniform Partition Properties Act recently been updated?
It has been recently updated in New York. It's been updated in New York, but it's been passed in a number of states. Alabama has had it for about 10 years now. But New York is the only state that has what we call the UPHPA 2.0.
So how soon is it coming to other states? and what is to be expected and what needs to happen for it to get to the other states?
So it's been introduced in a number of states that have not yet adopted it. So North Carolina, I think, is one of them. I want to say Kentucky may be the other. But there are some states that have not even introduced it into law yet. And so that's a major issue because you have to get the legislature on board to think that heirs property is a problem. In this current administration, I anticipate that it will be even harder to get the UPHPA passed in those states that do not already have it. And so states like Louisiana desperately need it. They are not even close to getting it, it seems. Because again, heirs property is an issue that disproportionately affects minority landowners and socially disadvantaged and socioeconomic landowners. And to get the legislature to really care about that has been a significant challenge. But not just the legislature. States like North Carolina do not have the backing of their local bar. I mean, their local bar does not want to see, I shouldn't say that. Their local bar has opposition to the UPHPA being passed. And some of the reason for that is the UPHPA adds these extra requirements that judges and clerks have to satisfy to ensure that defendants and landowners are afforded due process so that they can have a fair chance at keeping their land before it's ever sold to a third party. And it does require a lot of extra work on behalf of the judiciary and the staff of these courts. And so that is some of the reason for the opposition from the bar in North Carolina, for example.
But it's been weaponized to take property from Black and brown people over the years. And you said undervaluation. There's also been instances where the municipalities have overvalued the property for tax purposes to burden the estate that way. And people have lost their estate and heirs property because they were overtaxed. And recent studies show that Black and brown folks are overtaxed to almost 15%. It's the only time that they experience a high valuation is when it comes to property taxes. And they overtax and disproportionate representation from the benefits. So the work that you're doing in the updating of the UP, I know I'm about to mess that up.
UH.
is so important and okay, it's important and critical, and it's also an opportunity for us to bring awareness as we tour the country, informing the community on it. And what is the organization of attorneys that you are a part of that specializes in heirs property in all the different states?
So that organization is called HAPPN, HPPN. It's the Heirs Property Practitioner Network. It's a network that we developed, I would say about 2 years ago. It started at a Federation of Southern Cooperatives boot camp where Fran Miller from Vermont Law School brought a bunch of us together, a bunch of attorneys together at this boot camp and organized this network. Now, we're not formally organized, but we are very involved. We meet monthly, sometimes more than once a month. We've already had one in-person retreat at Wake Forest Law School. We have another one coming up in October, and we've spoken at many, many events, including the Professional Agricultural Workers Group Conference. We've spoken at Boston Law School, where Thomas Mitchell, who authored the UPHPA, had a racial wealth gap conference. And we're very involved in brainstorming and supporting each other in this work, since it is so specialized and it's such a small group of us.
Now, Thomas Mitchell, he's out of Boston College of Law?
He's at Boston Law School. Yes, sir. Okay.
And his initiative is on land, housing, and property rights. And he's doing some phenomenal work in that space. Why is this sort of just now coming to the forefront when it's something that people have been suffering from. It's been like a silent wealth killer for black and brown people for quite some time. And it's just now starting to gain some momentum. What was the impetus driving the awareness that's being brought around now for heirs property?
So I'll say this. So the UPHPA is fairly new. It's a wonderful statute that was written by Thomas Mitchell or authored by Thomas Mitchell and others. And he's worked very hard to get it passed in those states that have passed it. But it is fairly recent. Alabama was the third state to pass it in 2014. It became enacted or effective as of January 1st of 2015, which was 10 years ago now, but it wasn't really being widely used in the courts, I would say, until about 3 to 5 years ago, which is concerning. But I do want to give credit to some of the people who have been working on heirs property since the early 90s, late 80s. That would be Dr. Cassandra Johnson Gaither, Dr. Robert
There
Zavala.
are people that make millions and millions of dollars a year by predatory heirs property practices. And that is somewhat concerning, but in speculating and in business and in a capitalistic society, it is what it is. I believe it's incumbent upon us, though, to do the work in order to educate people in the space so that they have some awareness on how to be able to combat this loss.
Yes. Yeah. No, I totally agree.
So there's the UPHPA in place.
Yeah. Mm-hmm.
What else because not every state is even, signing on to this. What else can the states do to try to help mitigate the losses happening with the families?
Yeah, so I think education is definitely a role that there is to play, but also the attorneys. I think it's very important that the attorneys that work in the real estate space or who don't work in the real estate space begin considering working in heirs property. I think one of the biggest issues that I'm seeing is actually a lack of competent attorneys that want to do this work. And there's good reason for that. I understand why there are so many attorneys that don't want to do this work. It is very traumatic. It's very time consuming, and it's an underpaid practice area. So, I mean, you're not getting rich off working in heirs property, not going to happen. So, there need to be more attorneys that work in this space, because the reality is the only way to truly clear title is to have an attorney to assist you. Clearing title is a legal process. And so you've got to have an attorney to help guide you through that process. And so part of me thinks that, there have been some pro bono clinics and some law school clinics that have come up that provide pro bono legal services for landowners to clear title. But they're limited in what they can do because the grants that they receive only allow them to go so far in their assistance and legal services. There are also private attorneys like me who do this work and help people clear title from the very beginning to the end. And these landowners do not have the money to pay for legal services, but there are no grant options available for private lawyers to provide these services. And there are some things that private lawyers can do that pro bono lawyers cannot. And so I think that there needs to be a rally around how we fund the clearing title process, and all of this private money that's being poured into heirs property. I don't know where the money is going, but I hear about it in the news all the time from larger organizations. I would love to see them pouring into attorneys that are actually clearing title and are actually walking that process, and not just talking that process. So that's some of the things I think
a couple of banks have some initiatives now that they're working on. And then the Federal Home Loan Bank, I know, is doing some work in that area. And I guess the Federal Home Loan Bank out of Atlanta covers the Southeast District. Where would you say the largest concentration of heirs property is located?
So the Federal Home Loan Bank did run out a funding program. The awards were supposed to be announced in December, and it's February. So, we have yet to see that money. I'll just say that, okay? So, I mean, there's been a lot of like initiatives that have been launched, but they have not been launched. You know what I'm saying? So yeah, there's that. And then there's, the Heirs Property Relending Program, which never rolled out. So, that was what it was. But as far as the biggest concentration, I mean, obviously the Southeast United States has the biggest concentration. As far as states, that's more of a question for like our, data researchers, Dr. Ryan Thompson, people like that who have that data and those analytics. Alabama has astronomical amounts of heirs property, especially in West Alabama and what we call the Black Belt. And so it is very concerning.
What is the difference between, let's say, heirs property and heirs real estate? Is there a difference?
No.
So, as opposed to land and the farms, and then would you go north and northeast or west where it's more housing and real estate?
So what you're referring to is urban heirs property versus rural heirs property. And so that's what we refer to it as is urban heirs property in our cities and larger towns, and then rural heirs property, which is what we call your big white whales, the huge pieces of acreage. There is a difference between urban and rural heirs property in that there is much less likelihood that you will get what we call a partition in kind, that physical division I was talking about for urban heirs property. If you've got a brownstone and it's urban heirs property and it's owned by a bunch of heirs, you can't chop the house in half like a cake. It's not really eligible for any type of partition in kind. It's really only eligible for sale. And so in that situation, the way you would work an urban heirs property case is kind of different than how you would work a rural heirs property case. With rural heirs property, you've got more land to work with. You've got more pie to slice. And so that is kind of more of an option for some rural heirs property owners. It is not an option at all for an urban heirs property owner.
So that changes it up significantly.
Yeah,
as
it
far
does.
as
I mean,
even
under
with
the HPA, yeah.
Even with the valuation, it changes it up because it changes the inability to fractionalize the interest and sell off the pieces is interesting. But where do we go from here in order to, how long does it take to clear the title? And can you walk us through the steps of clearing the title?
Yeah, so clearing title can take a long time. Sometimes it's, if you've got less heirs, like say you've got less than 5, it could be less of a time because a lot of it depends on the family, to be completely honest with you. A lot of it really just depends on if the family gets along, if the family is on the same page. Most of the times they're not. And so if the family is on the same page, we can get it done fairly quickly. If they're not, you're looking at sometimes years. I've cleared it as quickly as 6 months, and I've seen it not be cleared. I mean, I guess the longest case I ever had, I didn't come in until the 18th year, but the Woodson case out of Auburn, Alabama, Lee County, Alabama, was a 19-year case. And that is probably the longest case I've seen. But the process for clearing title for me really begins with, number one, a consultation. And you should absolutely consult with an attorney. But even before that, there are things that the family can do on their own to save some money. And that's number one, to create a family tree. And there's some things that should be on that family tree, starting with the ancestor who originally owned the land. but also to go to the tax assessor's office and make sure the taxes are paid. Make sure that the taxes are up to date and that there's nothing overdue, so that it doesn't go to tax sale the next year. Make sure that you have a copy of the original deed to your ancestor. So go to the probate office and look for that deed from your ancestor. The other thing is to, consult with an attorney, take the family tree, take the original deed, take the tax property card, and figure out exactly what needs to happen to clear your title. Because every property, it's like a case-by-case basis as far as what the steps are going to be. But there's one thing that I don't think is negotiable, and that is a title opinion. And so every family, every heirs property owner, urban, rural, whatever, they all need a title opinion or a title search on their property. And what that is they have an abstractor or a title searcher actually go and search the probate records for all of the property records, everything that's ever been recorded in the probate office related to this property, liens, judgments, deeds, agreements, easements, whatever. And so that search is done, and then the attorney should review that title search with the family tree to issue a title opinion stating who all owns what. So these heirs own this fractional interest, and taking into account all of the records that are recorded on the property. That title opinion is crucial, because you don't know what you don't know. And how are you going to negotiate intra-family buyouts, buyouts between the family members, without knowing who owns what? How are you going to determine that there are no boundary disputes between your neighbor without, checking to see if there are boundary disputes? And a lot of the times in a title opinion, I'm checking for that. What about mineral rights? What if someone has accepted their mineral rights when they sold the property to your ancestor? Well, that means that you don't own your mineral rights. And that's something that you need to know before you decide to go, build a camp, a mining camp or something on your property. So a title opinion is very important.
That significantly impacts the value of the property as well, if you don't own the property or the mineral rights, which is another thing that we are able to take a look at. But also, and I don't know if it's happening in Alabama, but a lot of states have changed the laws, because I know here in Fulton County, just recently, you have to have ID before you can file a claim against a piece of property. And a lot of people, there's been a lot of land theft or loss due to false claims being filed. Is that the case in Alabama?
I mean, in Alabama, if you have a quitclaim deed, you can file it. So, I mean, legal land theft is what we call it. So things like adverse possession are definitely a problem in many states, but, even in Alabama, it's kind of what some people refer to as squatters' rights in a way. But basically, I mean, I could sign a quitclaim deed for any property right now and convey it to someone. And all I'm doing is deeding whatever interest I have if I have it. And so, I mean, I'm not warranting good title, nothing. I'm just saying, look, if I have an interest in this property, here it is, and you can have it now.
Anybody can just show up and file it. But now I do believe you have to have some identification and prove that you have a claim to file. And I know they just recently did that here in Fulton County.
I'm here in Alabama.
It's different in Alabama.
I don't know about other states, but I can tell you right now, you can show an ID to show that you're the person who, signed the document. But I mean, you don't have to prove that you have, clear title to the property before you file a deed. I mean, that would totally take away from the fact that people can adversely possess against valid landowners. And so then you're taking that right to adversely possess away from people who have the right to do so if they can show that they've actually possessed property for a period of 10 years with what we call color of title. So that quitclaim deed I was talking about, if I convey it to someone, let's say I give it to my neighbor starts possessing the property that I've conveyed for 10 years, actively, notoriously, exclusively, and openly to all others, and they start paying the taxes on that property for 10 years, they can file a claim for adverse possession in the court to say they're now the lawful owners. And whichever owners that owned that property, that let's say they live in Chicago and they just haven't been paying attention, they have the ability to legally steal that property from them.
And that's been the case for a lot of us, especially who who moved away during the Great Migration. But now I think there's an opportunity for folks to be able to come back and increase not only their wealth, but more importantly, the quality of life by returning back to the land and getting increasing food security, increasing wealth. There's opportunities to do mixed use rural developments, all types of things. Pharmacy, improving health through better quality food instead of dealing with the food deserts and with the high cost of food and housing. I think it's a natural progression for folks to start moving back. I believe it was the Allied Van Line and the U-Haul survey that recently stated for this year, last year, the highest number of folks are moving to South Carolina and North Carolina. Those are the top two destinations in the country. And I think for quality of life, land, housing costs, and just a great opportunity for us to get back to the farm.
Yeah, totally. I think that now is the time, especially, one of the things I advise
you all are frozen.
Oh,
you're not frozen. Oh, you're in there.
Am I frozen on my end?
Well, I'm gonna.
No,
everybody's fine.
No, you're unfrozen now. Like we're playing freeze tag. Now everybody's unfrozen. So
okay,
all that going on. So
no, all good.
This has been a really. Go ahead, Shonnie.
Oh, okay. I was going to say, Jacy, you were talking about, the importance of the title search and, with appraisals, dates for us are really important. And I was wondering, just for people who are listening, the families who are like taking notes and they're like, okay, let me get my affairs in order, and they're like, okay, I got to call, an appraiser and things like that. When you all are presenting this data and processing it and getting things together, what are the dates that you need? Do you need an appraisal that happened like last week? Could it be an appraisal that's a year old? Like, what is that for you all?
Yeah, so that's a great question. I'll do two different scenarios where we usually need the appraisal. Number one is when we're getting ready to coordinate those intra-family buyouts, buyouts between the family. So buying off those heirs who really just don't care what happens. Those heirs want the most recent appraisal possible. So they're wanting, usually the way it'll work practically is that we'll do the title opinion and the family will begin polling each other to see, okay, who wants to keep an interest in the land, who wants to sell. And those people who want to sell, they want a fair market value valuation, the most recent one that exists. And so at that point, the family will usually call the appraiser and order the appraisal so that they can get that back and then negotiate from there. In the UPHPA litigation, the Uniform Partition of Heirs Property Act litigation, the appraisal process happens as soon as we request it. So when the court orders the appraisal before the buyout rounds begin, the appraiser really kind of has like 30 to 60 days, depending on the state, to file that appraisal report. And the buyouts begin 30 days after the court assesses the value. So it's happening like very quickly, like the whole.
So in that particular instance, you're looking for an as-is effective date. Is there ever a time where you're looking for a retroactive date?
No.
Okay.
Well, I'll say this. The only time I have ever seen a retroactive request is when someone is sued for what we call contribution. And when someone is sued for selling timber, that they should have split the proceeds with their other family members and they didn't, the family members will sometimes want to know, okay, well, what was the price of timber when the price of timber was high? And the cost of timber varies year to year. And so when you're trying to determine the value lost from a family member that did not receive their proceeds from a clear cut or a select cut.
Well, that's important too, because I saw a case where somebody bought a fractional interest, and with their fractional interest, they sold all of the timbers, and they did not have to reimburse the other fractional interest owners because they had just as much right to the timbers as the other. So it was like who got there first, and they couldn't file like criminal charges. So is that a thing?
No. So it's not criminal charges. I guess it could be if you were looking at theft, but it's not really criminal. It's more of a civil action. So there's this legal theory called contribution. And so that person could have sued for lack of contribution, but a lot of people don't know that. Like, that's the thing. The average person does not know how to do that, number one. And number two, that they can even go to an attorney to figure out, well, what is my cause of action? And the cause of action is typically contribution. And so when you're an heirs property owner and you sell some of that property, which, the timber is attached to the land, it is an asset of the property, you are required to split those proceeds with your other heirs based on their fractional interest. The average heirs property owner doesn't even know who all owns what. That's why a title opinion is so important, because the average heirs property owner is like, well, I know that there's a bunch of heirs that own the property, but I don't know what fractional interest they own. And they're not thinking, like, oh, I need to share this. They haven't seen these people in 40 years, And so they're just not thinking about that. But there is a cause of action, and that cause of action is contribution.
So I think that one of the things that we talked about in the training was this needs to be an essential part of every family reunion, a business meeting.
I agree.
Talking about the heirs property. I mean, we can do that after the potato salad, after the dance contest, after the apple pie contest. But this needs to be an essential part of the family reunion and the business, family business sort of moving forward. And we're excited about being able to bring that level of awareness and have some impact because it's just super critical. And I am just really grateful and thankful for you coming on our podcast today. I am looking so forward to continuing to work with you in the future. And Miss Shonnie, I'm going to let you go ahead and close. Oh, don't forget to like, subscribe, and share our podcast, and please spread the word, and we really appreciate it. Shonnie, I'm gonna let you take us out. And Jacy, do you have anything else you want to say before Shonnie take us on out of here?
Well, I think that I want to encourage everyone, especially if you're a professional watching this podcast, to collaborate with people that work in this space that may not do exactly what you do. So lawyers, we cannot do it without title searchers, abstractors, appraisers, surveyors. We cannot do this work without the involvement of other professionals, real estate professionals, including realtors. Realtors, we have to enlist in lots of different situations. And it's the same for other professionals working in real estate. Don't take for granted the fact that clearing title is a legal process. And so, keep an attorney on call. We all need to work together to make this happen. We're not going to be able to do it on our own, especially now with the new administration. It is more important than ever for us to have a sense of community and for us to collaborate to actually get stuff done. And we're going to have to get creative. The grant funding terminology has changed very much. We just did some grant proposal evaluations as part of the Southern Risk Management Education Center. And there was a lot of terminology that people are going to have to start taking out of their grant proposals. And that's going to go for other things. I would imagine that would extend to tax exempt status with the IRS eventually. So let's all collaborate and get creative about how we can help these underserved communities retain their land and put a fill in the racial wealth gap.
And we are doing the same in the rebranding. We are rebranding. Our new website is 10kma.org. So we are changing our branding to the 10KMA Foundation, 10KMA Appraisal Foundation. So that's a part of our rebranding with everything that's going on in the space. And everybody is repositioning so that we can have successful outcome for our community and the people that we are impacting and trying to help. And Shonnie, I said you were going to close us out and take us home, but I wanted to make sure I made that one last little point.
Yeah, absolutely. Well, in the real estate space, we're working with clients who are experiencing having to sell property that belongs to family members and things like that. And so what I have found is that the word is getting out. People are really preparing themselves. People are really out here doing what it takes to make sure that they can convey their property properly. And so being able to have to know that it's time to start asking questions. If you're watching this podcast and you're thinking to yourself, I don't know what they're talking about. How do I get started? Well, you got to ask for help. You got to ask for help. You got to reach out to attorneys. You got to reach out to people like Thad and myself to figure out where do we start first? How do we get these conversations going so you can protect your family's interests? These families have had property in the family forever, and you don't want to mess around and fumble it. That's not what the ancestors want. So I encourage anyone who's watching this podcast to go ahead and reach out to us. Get the conversation started. Let's figure out how we can assist you, point you in the right direction. We don't have all the answers, but we do know people that can assist you with making sure that you protect the interest of your family's property. Yeah, that's that.
Absolutely.
Well, that's it. That's our call, folks.